Hi everyone, welcome back to my channel, TheRealLauraB. Laura here. I am just popping on very quickly to do a quick an update about the verdict. I'm sneaking up here while the baby's asleep, and appreciate you watching, and let's get started. Hi, I'm Laura, also known as TheRealLauraB from Twitter. I'm a researcher, truth seeker, and a new wave internet journalist. I'm not a lawyer, nor offering any legal advice. Join me on a journey to draw the curtain back to expose key news developments in the world of celebrity lawsuits and current events. Let's get started. Hey everyone. So we had some friends that were there at the courthouse today who reported back. Casablanca's girl, also known as Becca to me, filed her handwritten notes for us to go over as best we could. And let's see if we can understand them. Okay, here's page 1. Started at 10:45. Ben and Elaine were chatting privately in the corridor. Harissa, there was a previous case that was a murder trial that Judge A sentenced a man to life in prison. Ben said he watched the case and it was crazy. Agnette stated that she's having a terrible morning. Her camera equipment broke in flight on the way here, and her camera guy's at Best Buy right now trying to get her a camera. So and they have a new stenographer, so Judy's not there. So at 11 o'clock, it looks like the hearing's been called to order. There's 3 different issues. One is the semantics over Heard's counterclaim, and that could be red line of Mr. Chu's inconsistency, and I think we will see in the order that Ben files some objections. There is a post-trial motion briefing schedule that Judge Ascarati says, yeah, we're not putting in a motion to do that. Elaine is trying to get a hearing for Friday and putting together a opposition and scheduling order. And Chief Judge Ascarati says, yeah, this is my case. It goes the way I want it to go in trial, and it's not happening. And Elaine was trying to say, well, look, we're going to file July 1st, and Ben can have the opposition set for the July 6th and the hearing on July 11th. And Judge Ascarati is saying, yeah, I don't see a need for a hearing. This is done. We're finished. So I found that very interesting that Judge Ascarati is not messing around. Not messing around. So let's see what else was there that she shared. And this is what we were finding out in real time as soon as she got out the door before anything else was filed. Let's see if I can find her other one. All right, so here's the other part of it. So Elaine wants to do a post-trial motion. Judge Ascarati is saying the judgment's going to be filed today. We're done. And Elaine goes, well, unless the judge amends it. And Judge Ascarati says, I'm not doing that today. It's not going in the order. I am putting final on the order. Ben says, yeah, final order, no briefing schedule. But he does present his Exhibit A. So that we will see that attached to the order. No post-trial motions. I'm going to put up a copy of the final order, and that's it. And Elaine needs to sign it. The judge said, I'll sign it and give copies. And the hearings will be sealed. I need more information. We filed many appeals. We'll take a quick look at that order too. Elaine filed a bunch of notices of different hearings, different judgments, different rulings, and a lot of them were sealed. And Judge Ascarati says, yeah, no need. You have to unseal them if you're going to appeal. And Ben says, yeah, the court was public. And Judge Ascarati says, my intentions is to unseal everything. Elaine says, incorporate judgment order. Jury sign is sealed. Block out the signature to make it public, which they did. Judge Ascarati also talked about that Elaine, they plan to appeal. And she goes, if you want to appeal, you're going to have to file a bond of suspension of amount of judgment plus 6% per year. Now, appeals typically take 2 years. And I'll come back to that. And I hope your honor had a great vacation. And Judge Ascarati was speechless because obviously Elaine didn't realize that she had just heard this terrible trial. So this is my understanding of what a bond of suspension is. If Elaine wants, or if Amber Heard wants to forego paying Donnie immediately, when she files an appeal, she's going to have to file a bond of suspension. That is a suspension from paying Johnny, but the bond will have to be in the full amount of the $10,350,000 plus 6% interest per year. Now, appeals typically take 2 years, so I don't know if she has to add to that bond. Now, a bond is insurance, so they would have to make some arrangement with some company that would be willing to put up a bond. That doesn't mean she has to put up the exact dollar amount in totals. She may have to put together some collateral. She has to find something. Maybe she has backers. But what we have to remember is there's 2 lawsuits here, my understanding. Johnny also has a judgment against him. So if he wants to avoid paying her right away, he may want to appeal and put up a bond for the $2 million and wait it out. Maybe there's something that they can work out that to subtract the $2 million from her amount if she goes forward with the appeal. But the judge didn't write any of that in her order, so I'm not sure that works that way. So why don't we take a look at what the ultimate order came out to be? And then we'll talk some more on that. All right, here's the judgment order. This matter came to be heard before a jury in this court beginning on April 11th, and it continued through all these days, with the jury deliberating May 27th. On May 31st of this year, returned a verdict on June 1st. Before the jury were 3 counts of defamation brought by the plaintiff, John C. Depp, and 1 count of defamation brought by the defendant and counterclaim plaintiff, Amber Heard. At the conclusion of the trial and deliberations, the jury returned a verdict in favor of Mr. Depp on all 3 remaining defamation counts and awarded Mr. Depp $10 million in compensatory damages and $5 million in punitive damages, and a verdict in favor of Ms. Heard on her defamation count, one of them, and awarded Ms. Heard $2 million in compensatory damages. The jury verdict is hereby incorporated into this order by reference and made a part of this order. It is therefore ordered that the jury verdict of $5 million in punitive damages in favor of Mr. Depp is hereby reduced to $350,000, the statutory cap pursuant to Virginia Code. And it is further ordered that with respect to the complaint, judgment is hereby entered in favor of Mr. Depp against Ms. Heard in the amount of $10,350,000, with interest at the statutory rate of 6% per year from the date of this order. And it is further ordered that with respect to the counterclaim, judgment is hereby entered in favor of Ms. Heard against Mr. Depp in the amount of $2 million, with interest at the customary rate of 6% per annum from the date of this order. And we're going to go down and see that, I'm going to go past this and come back, that they did file the special verdict form with all the yeses on the 3 statements from Mr. Depp. And the judgment against Amber, they had put $10 million in punitive damages. They put $5 million. So that was recorded. And here's Ms. Heard's. No on her first statement. Yes on the second statement. No on the third statement. And here's the official warning of $2 million with no punitive damages. So this is the signature of the 4 persons, and it's been registered. Here's something interesting. Mr. Depp did file with this order objections that he can preserve against this order. And he did this, I believe, in case they have 30 days to appeal. Mr. Depp may choose to appeal. Mr. Depp may choose not to hand over $2 million to Ms. Heard and believe that this was an inappropriate verdict, an inappropriate amount, and he may appeal. They've never said anything, but they do have that option for 30 days. Plaintiff and counterclaim defendant, and he's appealing specifically, these are being filed against only the counterclaim award, objects to the final order on the following grounds. All reasons stated in oral and written arguments in Mr. Depp's demurrers, plea and bar, motions for summary judgment, and motions to strike. All reasons stated in oral, if I can make this big for you. All reasons stated in oral and written arguments in Mr. Depp's motions, jury instructions, and motions in limine. That's anything that they felt was inadmissible that they didn't win on. The court's legal finding that Ms. Heard could prove actual malice by relying on mens rea of either Mr. Depp or Mr. Waldman and permitting Ms. Heard to argue the same to the jury in closing. The court's failure to exclude inadmissible hearsay statements. So they believe that there were some hearsay statements that were brought in that shouldn't have been. The court's refusal to sustain Mr. Depp's objections to improper argument made by Ms. Heard's counsel during closing argument and motion for a curative instruction. Ms. Heard's improper argument at closing told jurors that a finding in favor of Mr. Depp would send a message to every victim of domestic abuse everywhere, which is an improper invitation to jurors to decide the case on larger social issues and to place themselves in the shoes of Ms. Heard when reaching their verdict instead of basing their verdict on the evidence presented. Now, there's been a lot of legal commentators that have suggested that maybe the jury threw her a bone on this, which would fit into this paragraph. They felt bad for her. Like, you know, you definitely defamed Mr. Depp, but, you know, maybe he wasn't so nice to you in the marriage. So, or maybe this would send a terrible message. So we're going to give you something. The jury's finding of defamation by Mr. Depp as to the statement made by Adam Waldman, that's a long statement that we know how they set up and detailed the hoax. Quite simply, this was an ambush, a hoax. They set Mr. Depp up by calling the cops, but the first attempt didn't do the trick. The officers came to the penthouses, thoroughly searched and interviewed, and left after seeing no damage to face or property. So Amber and her friends spilled a little wine, roughed the place up, got their story straight, and under the direction of the lawyer and publicist, and then placed a second call to 911 as contrary. This statement that they feel is contrary to the law and supported by the facts. And there are a lot of facts in the case, especially Mr. Waldman's deposition, where he had lots of other sources to counter her claims. The jury award of $2 million in favor of Ms. Heard against Mr. Depp in connection with the jury's finding of defamation was excessive and not supported by the facts. She never proved she lost any work. She claims there was some movie that she didn't get cast for, some movie that they never even presented ever was released. Hamada, his testimony from Warner Brothers, explicitly said that nothing in this court, nothing of Johnny's claims impacted their decisions to pick up her option or limit her role. All other options by Mr. Depp stated in oral or written argument in the record of this matter. Let me bring up what Elaine filed that I think that they were discussing. And this confuses me because Elaine did not preserve any objections in this order. And I think what she was arguing about wanting to have a hearing was because she still wanted to file some objections. And Judge Ascarati says, no, this is it. This is our last time together. So Elaine did file this on behalf of Amber. And I think this is what she's talking about, preserving all these things for the appeal, but marking them under seal. Under seal. So many things marked under seal. These would be from hearings, de voir dire, also any rulings on hearings. But look more, key objections for depositions. All these depositions, all things filed under seal, And Judge Ascarati made it very clear, no, if you're filing something for an appeal, this was an open court. Ben reminded him, this court was open to the public. Everything, if you're going to appeal it, you can't appeal it under seal. Nothing can be under seal. But I wonder if, and this is speculation for me, this hearing that Elaine wanted to have on July 1st could have been for her to put her objections to this order on record, because there were none of hers preserved attached to this order. There's just this notice of filing. And that's interesting, I think. Now, somebody else posted something on one of my tweets, and I don't know where it came from, and I haven't been able to confirm it. But it might have been somebody else who was at the courthouse. So let's see what we make of this. Okay, this is an Instagram story, and I'm not sure who it came from, but it was posted under one of my tweets. Let's talk about something else. Elaine was pushing for another hearing in court today. We know that. She was asking to have the judge agree to an on-the-record briefing schedule. She kept bringing up to the judge about this hearing over and over, and we saw that in Becca's notes. And this is what I can't confirm. The only purpose of the hearing would have been to extend the amount of time would be to raise the funds for the bond suspension. Elaine was trying so hard to get an extra 3 weeks. With that said, we can only assume a book deal is getting signed or a loan or other project is in the work to raise funds. Expect an Amber project soon. Elaine did not want the judgment to be set today. That was her main goal. Well, that does fit with my thinking that she wanted to get more motions filed or objections filed, but I don't know about getting a suspension of the judgment. So how does this all work at this point going forward? I'm not a lawyer, but I've been given a lot of information, and this is my understanding. Amber Heard has 30 days to file an appeal on her lawsuit. Johnny Depp has 30 days to file an appeal on his lawsuit. We do not know if Virginia has any kind of ruling or law to subtract the $2 million to wipe it out. I know a lot of lawyers are researching that right now. We don't know. So let's assume they can't subtract the $2 million. Amber Heard has an option within 30 days to file her appeal. She does not have to put a bond up to file an appeal other than for the basic cost. If she files an appeal without a bond, it's up to Johnny then to come to her to collect the judgment. She doesn't have the money. She's already said she doesn't have the money. I don't know that she owns any assets to cover over $10 million. A lot of people refer to her as judgment proof. Like, come on, come at me. I don't have the money. So let's say Johnny were to come after her. I think typically they use a collection agency for this. I don't think it's Johnny to her. I'm sure Ben might go to Elaine and said, hey, we want our money. I guess. Could Amber Heard file bankruptcy? I don't know that bankruptcy protects judgments. I know it can, if you file bankruptcy, and I know this from doing real estate, I know that there's a lot of home exclusions. They can't take your primary residence or up to a certain amount of its value. They can't take all of your income because they know you need to feed your family and stuff. So there are limitations in bankruptcy. I know your tax bills are not covered under bankruptcy. So I don't know what would happen with a judgment a defamation judgment with malice, with this kind of tort would be covered under filing bankruptcy. I think not paying your legal fees might be covered under bankruptcy. So that's one option, but it puts the ball in Johnny's court to have to go after her for the money. And I think she believes he won't do it. So I have a feeling she won't be putting the bond up. I have a feeling there's no money to be had from her. But now we conversely have Johnny's side because it is kind of a separate lawsuit. It's a separate judgment. If Virginia won't allow him to subtract the $2 million from hers, I can only assume the lawyers can do something to file for this, like a promissory note of some kind saying, I accept this $2 million towards your, let's say she goes for the appeal and doesn't put up the bond and Johnny wants to collect the money. He can say, okay, I'm going to apply this $2 million to your payment. I don't know if he can do that, but I'm sure this is the stuff lawyers are going to have to talk. This is the stuff we can only speculate about. So let's go the other side, that Johnny, for some reason, has to pay her the $2 million. He can write a check to her. I would hate to see that happen. What he could do is maybe write a check and hold it in abeyance somehow. Like, I'll pay you when you pay me, and I'll gladly pay the 6% interest. And if you don't like that, take me back to court. I don't know, speculation. Or, as we've seen, he's already recorded his objections. He has 30 days to file an appeal. And he could take his $2 million and put it with 6% interest, say it's going to take 2 years, into a bond and go, yeah, I'm going to file an appeal. Because I think this was a wrong decision on the judge's part to put my words through Adam's mouth. Not only that, but to also with malice, knowing it was reckless of the disregard for the truth, because Adam had a lot of other witnesses that would support what Adam was saying. So Adam was speaking with the knowledge he had that it was truthful. So there was no malice. And they mentioned that in their objections for summary judgment. So I don't know how this is going to play out in the end. I only know what's happened today. The judgment's been set against both of them. Amber's going to have to pay. Johnny's going to have to pay. We know, At 4:30 in the afternoon after the verdict, Elaine was out that door and in the ABC studio, probably like 6:30 in the morning to get ready for her interview, saying, we're going to appeal. They'd already decided they're going to appeal. So at this point, and then she did all these interviews, and there's rumors that she got paid for those. So maybe she is cash poor. So that's what we know today. There's rumors of a book deal, tell-all book deal. A publisher would be very careful because they know that she may be judgment proof, but they wouldn't be. If they're willing to publish a book knowing it's defamatory after seeing the verdict, they're putting themselves at risk. When it comes to a book deal, now, I know in their divorce, they have a confidentiality clause. And one of the things is not speaking about each other, not, disparaging each other. Now, she did go that route. When Johnny gave his interview for GQ UK, she sued him via arbitration, via the divorce confidentiality clause. And the judge denied her. And after that, she wrote the op-ed. He chose not to go the arbitration route. Instead of disparaging me, he went out and said she flat out defamed me. She flat out lied. So he went to defamatory civil action. I know it's going to go forward. It was an interesting day that so much came out of this. Again, the bond is insurance. It's not necessarily the full amount. And she only has to do that if Johnny demands payment. And that's pretty much what I got. So it was a big day, and I need to get back, take care of my new baby, and go see her in the hospital. So I hope you all have a great weekend and very interesting today, and I will talk to you soon. Thanks.